Hello friends, welcome to our next video in this series. We were discussing question paper of LDCE 2023 exam paper 2 for categories 1, 8 and 11. In this series, we will discuss question number 81 to question number 100. So let's begin with question number 81. It is question on CCA rules. Which one of the following circumstances shall not be a justification for placing a government servant under suspension? Statement 1 is where disciplinary proceeding against him is contemplated or is pending. So to find out the right answer, let's go to CCA rules on the right side. On page number 8 we can see rules on suspension. It says that the appointing authority or any authority to which it is subordinate, or the disciplinary authority or any other authority empowered in that behalf by President by order general or special, may place a government servant under suspension. So first statement is where a disciplinary proceeding against him is contemplated or is pending. So statement A is right. Statement B says where in opinion of competent authority he has engaged himself in activities prejudicial to the interest of security of the state. So this is also right by subpara A. Statement 3 says where the government servant has absented himself from place of duty without permission but resumed his duty after 15 days of such an absence. Now we know that in this case we don't suspend a government servant, we issue a notice to him. If he does not respond to notices, an FIR is launched and proceedings for terminations are started. So option C is actually incorrect. Let's also see option number D, where a case against him in respect of any criminal offence is under investigation, inquiry or trial. So under para 10 subpara B, this is also correct. So the only incorrect statement is C, hence the right answer is C. Next question is 82. Which of the following statements are not correct in relation to a suspended government servant who was dismissed from service but whose order of dismissal is rendered void in consequence of a decision of a court of law? So for this we again go to suspension rules on page number 8 and 9 of the PDF. In para 4 it says that where a penalty of dismissal, removal or CR from service imposed is set aside or declared void by court, government servant shall be deemed to have been placed under suspension by the appointing authority from the date of original order of dismissal, removal or CR, and shall continue to remain under suspension until further orders. So he will not be reinstated as given in option 1, that he will be reinstated in service from date of dismissal. No, he will be placed under suspension, he will not be reinstated. So option 1 is wrong. Again, he can be suspended again after being reinstated in service. So he will not be reinstated in service, he will be put on suspension. This makes statement 2 also incorrect. Statement 3 says the CVC has to be consulted as regards the further action to be taken by disciplinary authority. No, because disciplinary authority on its own, considering the circumstances of the case, can hold further inquiry. So option 3 is also incorrect. Statement 4 says that a further inquiry can be held on which you are dismissed only with the approval of President in consultation with UPSC. No, again we have read in this paragraph 4 of the CCA rules that disciplinary authority can do further inquiry depending on the cases circumstances. So all these 4 statements are incorrect, hence the right answer is D, 1, 2, 3 and 4. Next question is 83. It says that it is discovered that a government servant was not eligible for appointment in terms of recruitment rules more than 2 years after which he was appointed. That is, after 2 years it has come to knowledge that he was not eligible for recruitment. Now what action can be taken against him? So 4 options have been given. For this we will have to refer to DOPT's OM of 1993. Let's go to that OM. Now this OM And para 2 says that a question has now arisen as to whether a government servant can be discharged from service, whether it is discovered later that government servant was not qualified or eligible for his initial recruitment in service. So what action is to be taken? So this matter was examined in consultation with Ministry of Law and Justice, and it was decided that if he has become a permanent government servant, an inquiry as prescribed in Rule 14 of CCA rules may be held, and if charges are proved, the servant should be removed or dismissed from service. In no circumstances should any other penalty be imposed. So very clear-cut instruction has been mentioned. Now let us read the options given in the question. The first option says that an inquiry as prescribed in CCA rules may be instituted, and if the charges are proved, he should be dismissed or removed from the service. So that is correct. Option A is right. If we go through all other options, none of them will match with the guidelines mentioned in the OM. So option A is the right option. Now let's go to question number 84. Which of the following statements are correct in regard to review by President of orders passed under the provisions of CCA rules? So this question is about what additional powers President has to review or to revoke the suspension or any other penalty imposed. For that we have to refer to rule number 29A of CCA rules. Let's see what is the rule. So on page number 33, rule 29A on review, it says that President at any time, either on his own motion or otherwise, review any order passed under these rules when any new material or evidence which was not available at the time of passing the order under review and which has the effect of changing the nature of the case has come to his notice, provided that no order imposing or enhancing penalty shall be made by the President unless the government servant concerned has been given a reasonable opportunity of making a representation. So let's read the statement given in the question. The President may any time, either on his own motion or otherwise, he can review the order. If some evidence or some document comes to his notice which can change the course of case, so statement 1 is right. Statement 2 says the power to review the orders includes the power to review an order exonerating a government servant. So yes, if you will refer to Delhi High Court's ruling, and which is given in OM dated 6th of August 1981, this statement is also correct. You can Google for this OM. Statement 3, the power to review is in the nature of revisionary powers and does not amount to review of one's own order. So yes, this is also given in this High Court ruling. So option 3 is also correct. No order imposing a penalty can be made by the President unless servant has been given a reasonable opportunity to represent. Yes, so we have read it in CCA rules, this paragraph, that reasonable opportunity should be given to a servant before imposing a penalty. So all these statements are right, hence A is the right option. Question number 85. Which of the following does or do not amount to penalty within CCA rules? So in CCA rules, we know there are two types of penalties, minor penalty and major penalty. So in CCA rules, under paragraph or rule 11, both the penalties have been defined, minor penalties and major penalties. So before we go to the options, let's read that explanation given in these rules on page number 11, that the following shall not amount to any penalty within the meaning of this rule. So first is non-promotion of a government servant officiating, whether in substantive or officiating capacity, after consideration of his case, to a service grade or post for promotion to which he is eligible. So let's read the statement 1 in the question. Non-promotion of a government servant after consideration of his case to a service lower than for what he was eligible. So option 1 is correct, it's not a penalty. Option 2, reversion of a government servant officiating in higher post to a lower post on the grounds that are unconnected with his conduct. So now subpara 4 says that reversion will not be counted if it is not connected to misconduct. It will not be a penalty. So statement 2 is also right. Statement 3, reduction to a lower stage in the time scale of pay by one stage for a period of 1 year without cumulative effect and not adversely affecting his promotion. So this is a minor penalty and it's defined under Rule 11 subpara 3. Subpara 3 says reduction to a lower stage in time scale of pay by one stage for a period not exceeding 3 years. So here in statement it is given only 1 year. So option 3 is a minor penalty under Rule 11. Statement 4 says compulsory retirement in accordance with provisions relating to superannuation. So government can retire, and such compulsory retirement in accordance with provisions relating to superannuation as given in subpara 7 is not a penalty. So option 4 is also correct. Hence the right answer is D. 1, 2 and 4 are not any kind of penalties. Let's go to the next question. Question number 86. So now question on leaves will be discussed. In question paper you generally see that question related to a single topic like CCS, CCA rules or leave rules are in continuation. So now the questions which will be coming are from leave rules. So let's read the question. Leave up to what period can be granted to an aggrieved female servant on the recommendation of internal committee during pendency of inquiry under Sexual Harassment of Women at Workplace Act 2013. So for that we have to refer to leave rules. Let's see what has been given in the rules. So let's go to page 41 of CCS leave rules. So special leave connected to inquiry of sexual harassment under Rule 80. Under Rule 48 says that a leave of a period up to 90 days may be granted to an aggrieved female government servant on the recommendation of internal committee during the pendency of case or pendency of inquiry under Sexual Harassment Act 2013. So right answer is option C, 90 days. Question number 87. A government servant who has taken leave on medical certificate may not return to duty until he has produced a medical certificate of fitness in which kind of form? So for that we have to refer to page number 11. Now if you will see there are 4 options given in this question: form 3A, form 4, form 5 and form 7. So if you will read rule 19 you will clearly identify that form 7 is to be given when you have to sign a bond for availing study leave. Form 3A has to be given when disability has to be certified by a medical authority, and form 4 and form 5 are to be given if a non-gazetted officer is taking hospitalization with respect to a particular disease like heart disease, cancer, etc., or if illness takes place outside the CGHS covered area or outside the headquarters. So both form 4 and form 5 should be the right answer, but as per the UPSC key, form 5 has been given as the right answer. Maybe it is more suitable, and form 4 is actually also deals with hospitalization, so form 5 has been given as the right answer by UPSC key. Now question number 88. The decision taken by the government that both EL and half pay leave shall be considered for encashment of leave subject to overall limit of 300 days is based on recommendations of which one of the following central pay commissions? So the CPC of the 6th CPC, after which a DOPT issued an OM in 2008, made the decision that both EL and HPL will be considered for encashment subject to overall limit of 300 days. So right answer is option C, 6 CPC. Question number 89. Consider the following statements in context of recall to duty of a government servant before expiry of leave outside India. So suppose a government servant proceeds to leave outside India and due to some official exigency he is called back to perform official duty. In that case he is given entitled to some reimbursements. Let's see in which case what he gets. For that we will go to page 16 of the leave rules. Rule 23 says recall to duty before expiry of leave. So statement 1 of the question, it says the time spent by the servant on the voyage to India shall be treated as duty for the purpose of calculating leave. So when his leave is being regularized, whether this period of journey should be treated as duty or not has to be clarified. So in subpara 3b it is written that the period spent on the voyage to India will be counted as duty for purpose of calculating leave. So option statement 1 is right. He shall receive leave salary during voyage to India. So during voyage this period will be counted as duty, and what will he receive? He will receive leave salary during the voyage to India, and for the period from the date of landing in India to the date of joining his post at the same rate at which he would have drawn it but for recall to duty. If he had not been recalled, the same pay will be given to him. So option statement 2 is also right. Statement 3, yeah, that is also covered by subpara B, point number 1. Statement 4, he shall receive refund of his passage from India irrespective of quantum of leave left to be completed by date of leaving for India on recall. So if you read the leave rules and this question is asked in exam, it will strike to you immediately that some quantum is mentioned. It is not that irrespective of quantum he will be given a refund of his expenditure on passage. So if he has not consumed half of the leave period, or 3 months has not elapsed, whichever is less, he will be given a full refund of his leave passage, but there is no such condition irrespective of the quantum of leave left. He will be given a refund of expenditure on the leave on the passage. So this is also covered in the sub rule 3 of rule B, that refund of his passage from India if he has not completed half the period of leave by the date of leaving for India on recall, or 3 months, whichever is shorter. If this condition is satisfied, then only he will be given refund of his passage. So option statement 4 is wrong, and the right answer is 1, 2 and 3 only, which is A. Now question number 90. Which of the following statements regarding grant of special casual leave to a government servant for donating his or organ to another human being based on recommendation of government registered medical practitioner or doctor are correct? So for this we have to refer to DOPT's OM released this year in April 2024. So statement 1 says that special casual leave up to maximum of 30 days shall be admissible. Let's see what this OM says. A special casual leave of 42 days will be given to a government servant for donating their organs to another human being. So option 1, statement 1 is incorrect. Statement 2, special casual leave up to maximum of 42 days shall be admissible. So that is correct. So by general reading of this question also we can say that only option 1 or option 2, either one of them can be true. Both cannot be true at the same time. Both can be false, but both cannot be true at the same time. Then statement 3, flexibility or splitting of leave shall not be permitted. We'll come back to that later. Let's read statement 4. The maximum admissible duration of special casual leave shall be determined with reference to the type of surgery for removal of donor's organ. Now this statement says that it is a conditionally determine that how much duration of leave will be given. Now let's see the subpara 1 of this OM. It says that irrespective of type of surgery for removal of donor's organ, maximum of 42 days leave can be given on recommendation of government practitioner or government doctor. So there is no condition of involved on basis of which maximum leave duration will be decided. So option 4 is incorrect. As far as possible, treatment in connection with organ donation shall be done from any government hospital or CGHS empaneled hospital. There is no condition mentioned of getting the treatment done in a government hospital or CGHS empaneled hospital. Yes, but OM says about that approval of donor and duration of leave will be based on government practitioner or government doctor's recommendation. But the place of treatment is not determined by as per that it should be a government hospital or it should be a CGHS empaneled hospital. So option 5 is also incorrect. So we are left with option. Now what is asked in the question is the right option. So as 4 and 5 are incorrect, option C and D becomes wrong because 4 is incorrect. So even if you can eliminate statement number 4, you can reach the right answer, which is B, 2 and 5 only. And also we have seen in the PDF that option statement 2 is given is right and option statement 5 is also given is right. Now question number 91. Now what we are getting questions around GFR rules. So let's open GFR rules. Yes, so now the question number 91 says that loans owing to their irrecoverability or otherwise may be written off by a competent authority after prior approval of which authority? So this question is on waiving off or writing off loans. So for that we'll go to page number 280. Rule 259 speaks about irrecoverable loans. So competent authority after prior approval of Ministry of Finance may remit or write off any loans owing to their irrecoverability or otherwise. So this makes up statement D as right option, which is Ministry of Finance. Question number 92 says that a controlling officer of the central government may be entrusted with the responsibility of what? Drawing bills and making payments, incurring of expenditure and or collection of revenues, administering local funds, carrying out audit. So in the beginning of GFR, a lot of roles are defined, like what DDO does, what controlling officer does, who is HOD, who is HOC, who is head of office. So in rule 2, sub rule X or sub rule 10, the controlling officer is entrusted with responsibility of incurring of expenditure and or correction of revenues. So this makes option B as the right answer. Question number 93 says that the rejection of all bids is justified in which of the following situations? So when bidding takes place for a government work, when can all the bids be rejected? So let's see this on rule number 173. Under rule 173, sub rule 19, it says that rejection of all bids is justified when effective competition is lacking. So statement 1 is right. B says all bids and proposals are not substantially responsive to requirements of procurement documents. So statement 2 is also right. Statement 3 says bids, proposals or prices are substantially higher than updated cost estimate or available budget. So when the bidding amount is quite higher than what is budget available. And option 4 says only one of the technical proposals meets the minimum technical qualifying score. So even if one is matching the qualifying score, why will we reject? It is a common aptitude question. So when none of the technical proposals meet minimal technical score, then we can reject all the bids. But even if one is matching, then we will accept that bid. So option 4 is incorrect. So right answer is 1, 2 and 3, which is D. Question number 94. Government account means the account relating to consolidated fund, contingency fund, public account of India. So these are the three basic accounts in which government money is kept or public money is kept. So consolidated fund, contingency fund and public account. Public account is generally of banking nature, like bank deposits, and consolidated fund are generally deals with loans, bigger work like budgetary work, from where the actual budget flows into government account. Contingency fund is kept for contingency use, and recently the amount has been increased. Earlier it was of a very meager value, but now it has been increased to a good amount. So you can read more about these three funds in Rule 2, Sub Rule 16. So all three are government accounts. So option D is the right answer. Question number 95 says, in the context of GFR, consider the following statements regarding works. Public works, repair works, minor works. There are a lot of different type of works. So let's see. So chapter 5 in GFR is on works. So statement 1 says that what is a minor work? Minor work add capital to existing assets but do not create new assets. Yes, very true. Minor work add capital value to the existing assets but do not create the new assets. So this is correct. Statement 2 says that a ministry or department may at any discretion assign original works that are estimated to cost above rupees 30 lakh to any PWD or public work organization. So rule 133 says that without any limit, that a ministry, if it is an original work of any value, can be assigned to a public sector undertaking or in a central government or state government. So when it is original work, there is no value specified. But in case of repair works, the value is 60 lakh rupees. But in question we are asked about original works. So statement 2 is incorrect. Statement 3, limited tenders will be called for works costing up to rupees 25 lakhs. So we need to know the limit of the amount for which LT or limited tender inquiry is done. So in rule number 139, this is given that in subpara 5 that limited tender will be called for work costing less than rupees 10 lakh. So this statement is also incorrect, as the question says that limit is 25 lakh. No, it is up to 10 lakh that LT can be done. Statement 4 says that for projects costing rupees 100 crore above, the review committee constituted by administrative ministry or department shall have the powers to accept variation within 10% of the approved estimates. So rule 41 says that for reviewing of the projects, and after the project has started and costs 100 crore above, a review mechanism is made in which a research department is along with finance ministry representative, which is IFD, and the executive agency can review the progress of the work and can accept the variation within 10% of the approved estimates. Like if a project is of 100 crores, it can be raised to 110 crores if the committee is satisfied that reasons are just to increase the budget estimate of the project. So option 1, statement 1 and statement 4 are correct. The right answer is C, 1 and 4 only. Now we move to question number 96. In terms of GFR, value of performance security in the case of procurement of goods to be obtained from successful bidder who is awarded a contract is how much? So this has been changed recently. Earlier it was between 3 to 10%, but now it has been made between 3 to 5% as per the latest GFR, because 10% sometimes discourages the bidders from participating in the bidding process. So let's see where it is mentioned. Yes, so in rule 171 subpara 1, It's 3 to 5% of the value of the contract. So option B is the right answer. Question number 97 says that in context of GFR, consider following statements regarding LTE for procurement of goods. So LTE for procurement of goods, again one more question has been asked from limited tender inquiry. So the first is definition. LT method may be adopted where estimated value of goods to be procured is up to 50 lakhs as per the new GFR. But when this paper was made, this new GFR did not come, and as per that the limit of 25 lakhs. Generally in all the conditions it has been doubled in the new GFR. Like for single quotation it has been made 50,000 from 25,000, and for purchase committee it has been made to 5 lakh rupees from earlier 2.5 lakh Indian rupees. So statement 1 is right. Statement 2 says copies of bidding documents should be directly sent to firms which are shown on the list of registered suppliers for goods in question. Yes, so copies of the bidding document can be sent directly through various means like speed post, registered post, courier, email to the firms which are on the list of registered suppliers. Now statement 3 says the minimum number of supplier firms in LT should be at least 3. So rule says that it should be more than 3, not at least 3. So statement 3 is incorrect. Hence we have the right answer is 1 and 2 only, which is option B. Let's move on to the next question. Question number 98. In terms of GFR, no global tender inquiry GTE shall be invited for tenders up to what value? So for that we have to go to rule number 161, page number 38. In rule number 161, para B says that no GTE shall be invited for tenders up to rupees 200 crores. So option D is the right answer. Question number 99 says that the various classes of contracts and assurances of property which may be executed by different authorities are specified in the notifications issued from time to time by which authority. So for that we will go to page 58. Rule 224. This is covered in the chapter on contract management, and it says that all the contracts and assurances of property will be executed on behalf of President. Yes, and in the note section it is referred that the various classes of contracts and assurances will be specified through notifications, and these notifications will be issued by Ministry of Law and Justice. So option C is the right option. Question number 100, which is the last question of this video. Which of the following types of losses is considered as loss due to depreciation as per GFR 2017? So losses due to depreciation are covered in the rule 223, just above this rule. So you have to be very thorough with these two categories. Thus, what are the losses due to depreciation, what are not due to depreciation, because this theme has been asked multiple times, almost in all the years in paper 2. So which one of the following is considered due to depreciation? So rule number 223 sub rule 2 says that normal wear and tear is considered as loss due to depreciation. So option B is the right answer. Other losses which are mentioned here, like losses due to theft, option C, losses due to damage, and losses due to neglect, these are all losses which are not attributable to depreciation. So option B is the right answer. And this brings us to the end of this video. For more such videos, please like this video and subscribe to our channel LDCE Mediti, and stay posted. Thank you.